Hello, everyone. Welcome to SIC webinar today. My name is Qian, Counsel at SIC. If you know, we have quite a number of webinars this month, and this is actually the last one for the April webinar series. So in previous sessions, we have discussions on interim measures during COVID-19. We have, interesting and informative night chat with our president. We also have discussions on force majeure and guidance for the arbitrators. Today, we have formed an expert of three to share their views on how to effectively run cases of counsel's perspective, in particular, the oral advocacy and cross-examination for virtual hearings. Although I think that they don't need further introduction, but I will just briefly give you some background of the three very learned panelists. So first we have Ms. Sheila Ahuja, who is a partner at Overy's global arbitration team. So Sheila is quite experienced in various arbitration proceedings, including commercial arbitration, investor state arbitration, and arbitration-related court proceedings. And Sheila has particular experience in energy and infrastructure-related arbitration. And then we have Mr. Phillips, who has over 20 years of experience as a dispute resolution lawyer. And so Kent is quite experienced in handling cases, international arbitration cases in London and in Singapore. And of course, he has been recognized by various directories as a leading figure in this field. And finally, we have Mr. Nish Shetty, who is the head of Clifford Litigation and dispute resolution practice in Asia. So Mr. Shetty has quite a number of impressive titles, including chairman of SIAC Counsel Regional Committee for Singapore, and very interestingly, he is also a judge of appeal of the FIA International Court of Appeal in Paris. So Nish regularly advises on complex arbitrations and also acts as arbitrators on the various arbitration rules. Today we are very pleased to have all three on board to share with us their views and experiences. And after conferring with my three panelists, we decided to proceed this seminar like this. So I'm the moderator, and my role is limited to 1, timekeeping, 2, raising questions to the panelists on behalf of the attendees. So if you have questions, please press the Q&A button at the bottom of your screen, and then we will be able to see your questions. And please make sure that your questions are not too long, because if it's too long, I will probably skip it. And our panelists will be talking about oral advocacy for virtual hearings, and then cross-examination, and then some comments on virtual hearings. So without further ado, I would like to invite Nish for sharing some of your views and experience regarding the oral advocacy for virtual hearings. Nish, please.
Thank you, Qian. Hello, everyone. So let's start with oral advocacy as a concept. Now, most practitioners have been doing this, by this I mean arbitrations, for a while, would perhaps have done cross-examination of a witness that could otherwise not be at a hearing for one reason or another. But I think very few would have done an entire hearing virtually. Now, this whole COVID situation has brought this to the fore. So how does one deal with advocacy in that context when frankly, you're looking across screens and you're all in different places? And I'll also draw a distinction between the COVID situation that we have at the moment, where you're literally not allowed to be in the same room together, to virtual hearings that might take place post-COVID, depending on how this all plays out, and if people think that it's a good way to proceed even when you're not forced to be in different places. I think if we were to break this down, certainly in the COVID world, you're talking about two opportunities for oral advocacy. And I'm not including cross-examination in that. pure advocacy. By that I mean submissions to the tribunal. The opening would be the first real opportunity, and the second would be the closing, putting aside interlocutory hearings. In the context of opening submissions, whether it's a virtual hearing or a regular hearing, what I would say is first decide why you need one. By and large, most arbitration hearings these days, one would have written opening statements. Sometimes you also have, in addition to written opening statements, you have skeletal arguments. So by the time the hearing itself starts, you have two sets of submissions that should be with the tribunal, and assuming the tribunal is as diligent as most tribunals are, then those materials should have been read and digested by the tribunal. So what's the purpose really of an opening? By and large, you have the opportunity to piece things together in a succinct way so that the tribunal knows what to expect as the hearing unfolds. That's your real opportunity. Now, the best strategic decision you may make is frankly not to have an opening, an oral opening, because the written materials are there. But on the other hand, if you feel that that opportunity to set the pace, to set the scene for the arbitrator or arbitrators is an important aspect, then whether virtual or in an ordinary hearing, you should take that, because that will then be the anchor that the tribunal uses when considering the evidence that's to follow. So what then is the difference between a virtual hearing and a real hearing? In some respects, what you need I use real hearings, but by that I mean a physical hearing. Obviously, a virtual hearing is also a real hearing. The difference would be getting the attention of the tribunal, right? If you start from the proposition that the written materials are already there, and what you're trying to do is to set the scene and present in a way that will catch the tribunal's attention, then all of the rules that you would have for a physical hearing would ordinarily apply. So catch the tribunal's attention, even if you're speaking virtually. Do not try and speak like this, because even if it's virtual and the person has to look at you, what I'm trying to illustrate is pace is important. You have the ability to catch the tribunal's attention because the tribunal is looking at you through a screen. And how you present is all the more important because the individual is not there physically in close proximity to you. But I think it can be quite effective if you control the pace and if you deliver the message succinctly and clearly. I don't see a virtual hearing being any less effective than a physical hearing. The second aspect is what sometimes happens in the context of an opening, where you try and present materials. Now here, I think there is a difference between a physical hearing and a virtual hearing in how effectively materials can be presented to a tribunal. And I think it can go really well or really badly. So let's illustrate the two. Let's start with what really badly may potentially look like. Now, if we imagine that this is the hearing and I'm doing an opening, and I say to all of you as the tribunal members, I am now going to show you a PowerPoint presentation. Voila, here's the PowerPoint presentation, and there is silence. The PowerPoint doesn't appear, and you're then fumbling around trying to make the technology work. You have lost that opportunity to make an impact, because at some point in time, the tribunal is going to get a little fed up with that whole process. So the tech may stand in the way is the point that I'm trying to make. That's the first bit. So if you are going to use visual aids, tech tools, and the like, then make sure that you've seen how efficient it is, seen how effective it is, and make sure that the tech stands up to what you're trying to do and what you're trying to achieve. So that's the first bit. The second is, I'm just as a matter of my own preference, and I'm sure all of us and all of you will have different approaches to this as counsel. I tend to rely less on things like PowerPoint when making oral submissions. I feel that they can be quite distracting. They're useful. Visual aids are useful if the visual impact is what you're after. So by that I mean, if you're trying to say to a tribunal, this is the clause in the contract and it means that, you can do that by taking the tribunal to the contract itself and the clause itself, because the tribunal will have to go through the materials when deciding the case. On the other hand, if what you're trying to illustrate is a visual sort of image of the site, so take a construction or a infrastructure dispute, and you want to show what a power plant looks like and what a turbine looks like or whatever, and that's going to make an impact on the tribunal as that tribunal is going to listen to evidence from witnesses, then there may be a role for these visual aids. So in that sense, it can go both well and poorly depending on how well prepared you are and how strong the tech is behind the virtual hearing that you're going to have. So could be very effective or could go disastrously wrong if the tech doesn't keep up with what you're trying to do, or indeed if the messages that you're trying to give through those visual aids are really messages that are better delivered through other means. So from that perspective, you know, when it comes to openings, I think you should be A, selective about whether you need it. B, if you do need it, what are the core messages that you want the tribunal to take away? And that, frankly, whether it's virtual or a physical hearing doesn't matter so much. And 3, leverage the technology if it's going to give you if it's going to give you an advantage in setting the scene for the tribunal itself. Now, that's insofar as oral openings are concerned. What about closings? Now, closings, on the other hand, are equally important, if not more important than openings, because you're trying to tie your hearing together. You're trying to bring the points that have come out through the evidentiary process, and you're trying to point the nose of the tribunal to the points that you want to make. Now, obviously, many hearings these days do not require an oral closing. But given that we're talking about oral advocacy, I'm dealing with a situation where we actually have an oral closing. The same principles would apply there. Now, one of the things that most budding counsel will be told by less budding counsel is make eye contact with the tribunal and try and get the tribunal's attention. Now, how does one make eye contact virtually through a screen? Now, that's, if anyone knows the answer to that particular question, do chime in. I'm not sure how, other than to look directly at it as I'm trying to do now and pretend like I'm looking at the 1,500 people that have signed up to this particular webinar. But the point is still one about capturing attention, delivering the points clearly, and ensuring that you encapsulate your case in a way that resonates with the tribunal. So that's a sort of an overview of the points that I wanted to make in relation to oral advocacy. I know, Qian, that was a long overview perhaps, but I'm happy to sort of take further points from my fellow panelists or from you on this particular point.
Sure, thank you for the comprehensive introduction on the your tips regarding the opening statement and the closing statement in virtual hearings. I know that Kent has just finished one virtual hearing, so maybe Kent, if you have any views or tips for oral advocacy, you can share with us.
That's a very broad and open question, but I must agree with Nish's observations on these things. There is undoubtedly more pressure on the written filings, the documentary evidence, and that means you need to choose your points for opening and your opening presentation even more carefully than you would usually. It's in some ways, and this is a theme we want to bring out in this presentation, it puts more pressure on some of the basic skills in terms of advocacy when you put them into a virtual context. And I would agree wholeheartedly with Nish and his observations. One thing he mentioned in passing, and I've been doing this too, is talking about real hearings versus virtual hearings. And it's very easy to think of these as not real. And certainly what was good in the recent merits hearing we did virtually was, for each witness, we reminded them at the start, and the arbitrators did the same, that this is the final merits hearing in this matter, and gave it a really formal overlay in the same way you would in person. So the fact that you're sitting in your front room and looking at this on a screen in familiar surroundings doesn't detract from the seriousness of what's at issue here. This is a final merits hearing. It is a real hearing. It's quite easy to refer to it as something else than real, but it's worth keeping in mind these are final, and setting the tone at the start of the witness's evidence is an important part of that.
I totally agree. I think my slip at the start was one that sort of reflects a thinking totally. The other thing I would say is be careful how much you rely on your colleagues when you make these submissions, because if you're heavily reliant on individuals that can't be in the same room as you, whether for documents or for the law or whatever, and it's not unusual, especially for larger hearings, to have a team of individuals that are working on various aspects of a particular case, then you need to ensure that you have the ability to address the points that are raised, because don't forget, it's very rare, whether in an opening or in closing, that it's a monologue. The tribunal is likely to interject. The tribunal is likely to pose questions. The tribunal is likely to take the opportunity to clarify points. And you need to have the ability to get to the answers quickly while still, keeping the attention of the tribunal through the screen and so on. So to that extent, whether you have separate electronic lines of communication or otherwise, and we'll talk a bit more about this, I'm sure, as we go into some of the other issues. But I think it's equally important that the flow of the submissions isn't interrupted by the fact that you need to confer with your colleagues.
Thank you, Nish. Thank you, Kent. I think we have quite more questions. One is for Sheila. One of the attendees asks, what are some of the platforms that can be used for virtual hearings? So it's quite, nowadays there are so many different apps providing this video conferencing ones, and some of them are said to be, undesirable or unsecure. If you have any recommendations.
Sure. Thanks very much, Qian. I think two facets to what I want to say. One is to follow on from what Nish and Kent have highlighted, obviously all of which I agree with, is the importance of the appearance as an advocate. And I'll come on to your question, Qian, but just to add to what they said, all of which I think makes a lot of sense in terms of the differences between real and virtual, just to carry on with that comical difference. One thing that we think about is when you choose an advocate, or when you decide I'm going to be an advocate, you actually focus on your advocacy skills in many ways. So some people have a strong presence when they enter a room, and that in itself speaks volumes of someone as an advocate. Some people actually command respect or disrespect from a tribunal, depending on how they interact with their team. And some people just have body language that is naturally quite embracing, and the tribunal, you can sort of feel the tribunal physically following them into an argument. These are not tactics that one can quite easily deploy in this kind of Zoom screen that's sitting in front of me, when the only thing I'm focused on is the thunder behind me louder than my own voice as I talk this afternoon. So there are a lot of different mindsets, I think, that come into play when one thinks about oneself as an oral advocate, and that is the focus of our session. And I think there may be some resetting required. And I just want to give an example in that. I was reading an article, a BBC article actually, about the use of virtual means to communicate. And there's a professor at INSEAD who made two interesting points. He said that video chat means that we actually work harder to process nonverbal cues. So when we look at one another's faces on the screen, things like facial expression, as Nish was saying, tone, the pitch of the voice, and the body language to the extent you can see it, people pay a lot more attention to this than they otherwise would. And this actually, even from the person receiving, so say from the tribunal's end here in the context of hearings, consumes a lot of energy. So I think we need to focus on that as well, is how is the tribunal receiving all of this? And the second point to make there is silence. So he talks about silence creating a natural rhythm in real life conversation, but that when it happens in a video call, you become anxious about the technology and it makes people uncomfortable. And apparently there's a 2014 study where some German academics showed that delay on conferencing systems and phones shaped our views of people negatively, and that even a 1.2-second delay made people perceive the responder as less friendly or not focused. So these are hurdles that, again, we need to overcome. I think coming to your question, Qian, about how there have been platforms that can help us with this, and this is something I was going to address in my part, so I'm going to sneak some time into your bits by talking about it now, but very briefly is, of course, there have been lots of tried and tested platforms even before COVID days of virtual hearings. And now what we're looking at is who can provide the fullest virtual hearing package, because that is the end of the spectrum that we're moving to. So Zoom and WebEx are obvious contenders, particularly in Asia. I've certainly seen them as the, it comes at the tip of everybody's tongue. Should we do a Zoom? Should we do a WebEx instead of should we talk? There is Skype for Business, e-mediation, which was used by the Vismut, actually, with more than 250 universities, not to mention their arbitrators, using that platform. There's LoopUp, which I know certain chambers in the UK have used, as well as elsewhere. And of course, there was a GAR article last week on SIAC conducting its virtual hearing through Maxwell Chambers coordinating, and they used Polycom Real Presence as well as Blue Jeans. So there's a huge spectrum of options, and I guess the very long-winded answer to that is, the best thing to do is some research into who's tried and tested which and what suits you.
Thank you, Sheila. And actually, I think the points mentioned by Sheila regarding, those factors that cannot be imitated are quite interesting. And this is also one, advantage of in-person hearing. It actually happened in one of my very early cases when I just joined SIC. So what happened in that case is that one party is not based here in Singapore, is actually based in the faraway country in Europe. And another party is based in Singapore, and the sole arbitrator is also based in Singapore. So when it came to the stage of hearing, the Singapore-based counsel saying that, oh, we can have in-person meeting with the arbitrator, and you can just dial in. And the European counsel said, no, this will cause prejudice to us. So I'm not quite sure, in such kind of cases where the two parties do not have the same method for conducting the hearing, do you think there is a real concern for equal treatment?
So let me see if I can give my perspective. I'm sure my co-panelists will have their own views on this as well. I think as counsel, we tend to want to eliminate all variables. So the example that you gave, in reality, is it going to be that different? Is the outcome going to be that different if you are before a sophisticated tribunal? Probably not. So one counsel sort of dialing in, or arbitrator dialing in, or whatever, I don't think will materially change the outcomes. But you, as counsel, you're trying to manage that the limitation of variables, right? So you want to ensure that there's an equal sort of platform from which you can present your case. Even if it's a marginal difference, you don't want that marginal difference to exist. And the second part of it is also client management. Even if there is absolutely no difference, you don't want a client to pipe up and say, why did you allow that to happen? And that tends to influence these sorts of decisions, unfortunately.
Yeah, I think the only thing to add to that, and again, this is something I was going to pick up in the context of virtual hearings, is leaving aside the parties and their ability to convene at the same time and same place with the tribunal. What about the tribunal members on their own? I think there is a real question, and we are actually seeing this in some of our experiences, where 2 of the 3 tribunal members are in the same place, same jurisdiction, and as lockdown measures start getting relaxed, they can possibly meet at a distance of 1.5 meters, obviously, and the 3rd member cannot. So is there some subconscious in the parties' minds, let alone the tribunal, as to whether or not there might be more camaraderie building between the 2 who can meet? And overall, are we just in a far worse world in terms of tribunal compatibility and collegiality in circumstances where they can't have lunch together, you know, in hearing breaks, which is when we all know most deliberations happen, and you know, factors like that obviously play a part. Do they contribute to the fairness of the hearing?
If I might add to that, I think it's not always a level playing field to deal with virtual hearings as we now have to. There are situations you can see where, for example, in the current restrictions in place in Singapore, we can't, as a legal team, all sit in the same room. Whereas we might be up against counsel in a country where that is possible. And you can see how that might itself work in unfairness. That's a point I think that's already been made, that actually working together as a counsel team works a little easier in person when your expert is sitting next to you during the cross-examination of the other side's expert, or where you're reaching for that authority and you just can't find it in the bundle, but the 3 very clever lawyers next to you know exactly where it is and which extract you're looking for. All very hard in person, and sometimes it can present a strategic advantage to the other side. So it doesn't always work mutually.
Thank you for this. I know that our time is running, so let's now quickly move to the topic of cross-examination. I think Kent has some insight that he could share with us.
So I think the topics I wanted to cover under the cross-examination heading have really emerged in the discussion that's already taken place. I think Nish mentioned earlier that time is one of the real issues, and that pace is very important. Time seems to go very quickly in these virtual hearings, more so than in an in-person hearing. And in some ways, progress just seems to be slower in everything. And cross-examination is particularly that. And even more so where you're dealing with different cultures, different time zones, different technologies, and different languages. The language issue in itself is a formidable obstacle to fast progress. So pace and timing is one particular concern. Another that I think is already in play is the question of demeanor. So quite often in the context of cross-examination, the witness's demeanor is quite important. Sheila's mentioned body language. Actually, it's a very important part of communication, and the impressions the tribunal is forming are formed in small part, rightly or wrongly, by body language. By that 1.2 second delay, all of those things impact the way in which a witness gives evidence, and that plays out quite significantly in a cross-examination context, particularly where credibility is an issue, and I'll come back to that. I think the other thing that's missing is the atmosphere in the room, particularly when an important issue, perhaps the crux of the case, is an issue. It's going to be addressed in cross-examination with key witnesses, and there's sometimes an atmosphere in the room that's really difficult to replicate. Maybe it's a function of body language, facial expressions, demeanor in a more general sense, but I find that's missing in even the best virtual solutions. That's not unique to cross-examination, but I think it comes to the fore, particularly in cross. As I mentioned, it's really where credibility is an issue that these things come out. I think it's much more difficult to mount good credibility challenges in this virtual medium. My colleagues may disagree, but I think particular caution is required before making attacks on credibility in a virtual setting. That means you shouldn't where you have to, but be under no illusions. This is going to be a longer process potentially than before. And that really is a function, in my experience, of using the documents. And obviously, documents are critical. They are your refuge in questioning a witness. When the witness gets away, you bring him or her back with the documents, the ink on the page. And that practically, to get those in front of the witness in the tribunal quickly so as not to break the flow of questioning is really important. And that can be quite challenging in a virtual context. It just adds one layer of complexity. Do all members of the tribunal have the right documents in front of them? Does the witness have the right documents in front of them? Is the right extract there? Quite often, yes, but it takes a lot of organisation to do that. And if you're using extraneous materials, for example, in a attack on credibility, that is now even more challenging than before. Of course, that may be a good thing. Maybe there are just too many unwarranted attacks on credibility of witnesses in international arbitration. Sometimes these have no strategic advantage or no relevance to the outcome of the case. And sitting as an arbitrator, you wonder, apart from throwing mud at the other side, how is this going to impact the outcome of the award? So in some ways, perhaps the deterrent value around credibility might be a positive thing. Another point I would make on cross-examination is that good cross is a team effort. Quite often you only see the advocate asking the questions and getting the answers and thinking of the follow-up. In reality, there are invariably a team behind that in charge of the documents, designing the questions, knowing the answers before you ask the questions, and your ability to work with those teams when they're not in the same room is one of the real challenges, and I think we'll come back to this soon. So those are I guess the difficulties. In terms of the cross-examination, some of the useful tips and pointers, I'm sure we've all got our own experiences to share with us, but I think in some ways it just makes the basics more important. Use simple questions, get the pace right, particularly where there are different languages. The questioning technique, simple, tight, closed questions, single fact questions, not asking for opinions, all the cross-examination 101 is really put in the spotlight in a virtual setting. Likewise, putting documents to witnesses. If you're going to need to do that to pursue a particular line of questioning, you've got to allow time for that, and it needs a lot of preparation. And you've got to ask yourself, is this answer going to be important to my case? Is it going to feature in the closing submissions? Are we going to find it in the award? And if not, why are we pursuing this? Can we, and this is to build on a point Nish made, can we do this with documents? I think it might bring a bit more discipline around some of the topics we see pursued in cross. More generally are some basic human points. Patience and persistence are particularly important when there's slow going. You need to be very careful with interruptions. Speaking over a witness is not just rude, it creates chaos in a virtual setting. So sometimes it happens inadvertently, but letting the witness finish the sentence is particularly important in a cross setting. I guess the biggest point I want to make though is around the choice of questions and the choice of topics. Quite often as counsel, we're under pressure from clients, and I'm not going to generalize, but certain profiles of clients like to see their advocates push the other side's witnesses hard and cross. And that might mean aggressive questioning. It might mean topics designed to discredit them, to trip them up on questions of memory, to make them look silly or belittle them, or just to give the client the feeling they've had their day in court through cross-examination. And I think all of those endeavours are, if any of them are a good idea in international arbitration, they're a particularly bad idea in a virtual setting where the scope for it to go wrong is very considerable, and the chances of achieving anything useful out of it are even more slim. So I do think the move to virtual hearings at the moment will help discourage some of the more pointless cross-examination we see. that we see in all hearings in international arbitration. There's a Michael Fung article, or articles about some of the questions not to ask, some of the topics not to pursue. I think that's quite good wisdom, and particularly good wisdom now in this virtual context. So I'm hoping that that clients and counsel alike will feel a slight chilling effect on cross. That's not to say, of course, there are not important issues that need to be pursued in cross, and they still should be, with appropriate planning and particular emphasis on organisation. That's what I had to say on cross.
Qian, with your permission, I just want to touch on something that Kent ended with, and it's really, I think it's a very, very important point and a very, very good one. While this well, the current environment may have that chilling effect, I think what the current environment's also doing is basically creating some frustration amongst parties to hearings being put off or deferred on account of the current situation. And I'm beginning to see in the last couple of weeks a tendency towards saying, look, let's just get on with it. A virtual hearing is the way to do it. I think if you don't carefully consider some of the points that Kent just mentioned, particularly if your case is going to turn on credibility of witnesses, then you're going to have to grapple with things that might turn out to be that might turn out to be material to your success. And for that reason, I would say think very carefully about whether some form of virtual hearing is fine, but if it's a complete replacement of the traditional physical hearing, that might not be appropriate for every single case out there. I certainly think that there are many, many cases out there where this will be absolutely fine, and those issues, as Kent's rightly pointed out, will not play out and have a material impact on the case. But there are other cases where I think one should consider carefully whether it is or is not appropriate.
Thank you, Nish. So Kent mentioned some of the interactions that one may have during cross-examination, and we just received one question from an independent arbitrator here in Singapore. So he asked Kent, how would you react if in the middle of an intense cross-examination, the internet connection of the witness goes or appears to be down?
So things get very hard for the witness and suddenly he or she is offline. I think that's, as arbitrator, maybe an eyebrow goes up the first time, but that by itself, it's hard to read too much into it. I think it's just like any other sort of break. We need to call time on it and reconvene in 5 minutes. I can't see any other practical way through it. If it keeps happening, depending on the timing, then it's really hard not for something like that to be one of these small things that starts to make an impression in its own right. But if the internet connection goes down, I think we've just got to have plan B in place. That may come on to a point I think Sheila's going to cover about the technology supplier. And this is where using one of the big names, normally with someone who moderates this process and looks after it, it can be a false economy to proceed without that. That minimizes the scope for these things to happen, and they can intervene pretty quickly to sort it out when it does. So that's, I guess, the only answers I can give to this difficult situation. I would like to know more about this, perhaps not on this forum.
Thank you, Kent. Now let's move to the next topic regarding the virtual hearing generally and on its details. So Sheila, please.
Thank you, Qian. So just on the back of Nish and Kent's points, I'm going to try to be additive rather than repetitive and focus on how we can use the fact of a virtual hearing and its features to better suit us as advocates. And I'm going to try to do this with 4 points, and I'll try and keep each one of them short, or else I guess somebody can just disconnect me. The first is I'll try and deal with embracing the proposition of virtual hearings and just talk a little bit about that and how that's going. Secondly, I'll talk about how we need to recognize as advocates the body of know-how already available to us to get it right, even if we're doing it for the first time. Then I'll talk about reminding yourself what the goal is here as an advocate and how you can fulfill that at least to the maximum of your ability. And then, of course, finally, I guess just something more light-hearted is turning your mind and avoiding certain pitfalls, which I'm sure we've all probably experienced in one context or another. So embracing the idea of virtual hearings, there's obviously, and even in this context, Kent, I think you mentioned that this discussion around, you know, to hear or not to hear, and as Nish was saying, we have seen before one of the first reactions to COVID imposing such sort of nationwide lockdowns is the immediate default of deferring hearings. I think there is still a school of thought, whilst people are trying to go ahead, nonetheless virtually, there is still a school of thought that the longer and more substantive the hearing, the more the risk of delay and the more likelihood of it being an unsuccessful virtual hearing. And so thus the propensity, I guess, for delay. And I think you rightly said, Nish, you know, it's sort of fact specific in that situation. And I'll actually come on to deal with that. What we have seen actually in terms of embracing virtual hearings is from the court's perspective, there have been legislative changes in various jurisdictions to direct or allow virtual hearings in certain situations. So at the court level, we've actually seen this, you know, spread quite quickly. And actually even pre-COVID, back in 2018, as I was looking this point up, there was a court in the US that actually rejected the argument outright that there was a blanket right to in-person hearings to begin with. So there was never really a mentality that you must convene in person so as to check the merits hearing box. Recent, of course, post-COVID legislation has been more specific to how to enable complete virtual hearings. And that's also generated case law around the region and more sort of further along. And although most of you will be familiar and be getting lots and lots of bulletins about these cases, I'm sure, I'll just focus on this English case called Municipio de Mariana and BHP Group. And this was a very recent decision, obviously, with a remote hearing on the 17th of April, judgment issued on the 20th. And what the court did there is analyzed COVID-19 related decisions. And then the court discerned 5 principles governing whether a hearing should be adjourned or whether there should be a remote hearing instead. So just to the question of to hear or not to hear. And I'll leave you to go and look up the 5 principles, because we must give you some homework here, right? But there are 2 points that I do want to focus on. One is that the court said that there should be a rigorous examination of the possibility of a remote hearing, including certain predecessor judgments in which the court ordered going and checking the bandwidth of the party's internet connection. So really quite specific and tech savvy, I would say. And the second point is inevitably the question of whether there can be a fair resolution by way of remote hearing is case specific. And this is just going to the point that Nish made, which I fully agree with. But then there are some jurisdictions in which court virtual hearings haven't been embraced as much. And I'll just give one quick example. 2 days ago, the Bar Council of India chairman wrote a letter to the Chief Justice of India, basically asserting that virtual hearings post the lockdown period are impractical, and stating that any continued form of virtual hearings ignores the ground realities in India, and in particular, the disparity in terms of access to technology. That is obviously a prerequisite for virtual hearings. So you can see sort of people are, you know, being more vocal about whether this works and trying to shape the future as best they can. But then, of course, moving to the arbitration context, there's actually a lot of learning and know-how that already exists. So I'll highlight just a couple of examples. There's the joint statement on COVID-19, very recent attempt, obviously. And this was issued by leading institutions, including our very own SIAC. And the content is to encourage collaboration between parties to make the best use of digital technologies for remote working and hearing. Now, I think this is a really good starting point because the message in the community is we're geared up for this and we're going to respond to this by way of proceeding rather than delaying. Then when you take a step in and look at institutional rules, actually a lot of them already envisage some form of virtual presence, whether it's for witnesses or hearings or just technology in general. And taking a step further back, there's actually a wide power for tribunals to push the sort of enabling of hearings to proceed, and an expectation that the parties will cooperate, and sort of along the likes of what is contained in Rule 19.1 of the current SIAC rules. Now, moving along to what has then been issued post-COVID in terms of institutional support, there's obviously various virtual hearing protocols. And if you were all in front of me, all 1,500 of you, I might quiz you on some of these protocol provisions, because there's quite a lot of them, but I'll just read out the list, because obviously I can't see any of you. Or I could ask Nish and Kent actually for humor value, but I'll just list them out. So there's the Hague Conference Guide on the use of video link under Evidence Convention. There's the ICC Commission Report on Information Technology and International Arbitration. There's the CIR Guidelines for Witness Conferencing. And more, I think relevantly, there's the Seoul Protocol on Video Conferencing in International Arbitration. And post-COVID, the DLOS Checklist on hearings in times of COVID, and the ICSID Guide to Virtual Hearings. Now, just focusing on the Seoul Protocol for a moment, if I may, I'll leave you to look at these documents more closely, as in when you get to a virtual hearing imminently, you'll find that actually they do educate a fair bit. But one or two examples from the Seoul Protocol. One is that in terms of documents, the protocols suggest several measures that are actually already common in arbitration, but so that you can focus on and provide for them specifically. So an agreed bundle of documents and how they'll be provided to each party, what form, and the tribunal, and of course the witness, to facilitate referencing so that you're not distracted by this quite practical point amidst a hearing. And then also it focuses on technical requirements and sets various minimal technical standards that of course avoid this idea of being intercepted by poor quality and delay. And it provides what I think is very useful actually, a checklist for practitioners engaging with technical providers to overcome. I can say that prior to COVID, I was a dinosaur with IT, and now I feel I can probably sort of part-time in A&O's IT team. But you know, this is partly what we need to do, is sort of come up the hurdle of educating ourselves. But the upshot of these protocols is that they provide the guidelines which facilitate what logistics you have to think about for a virtual hearing, but more importantly, to avoid disruption and distraction for the advocate in communication with the tribunal in the course of the hearing. And it's sort of designed to achieve what is meant to be the case, which is to capture the full attention of the tribunal on the purpose of the hearing itself, which is actually to decide your case. I've talked about the various platforms already. I listed them out for you. I should also add that in terms of electronic bundle providers, there's also Epic and Opus 2, and I know they've been used very, very widely, but they've also been successful examples. One practical point I think which is critical here is test runs. I think it's very useful to do them. I've just done one actually yesterday. As advocate, sometimes you feel you're not going to join the logistical part of it and you turn up on the day. But actually doing test runs is useful in a technical sense to test where do you want your gadgets and how many do you need. And more importantly, and this is a sort of human point, is it provides a good icebreaker. You actually see the members of your tribunal secretary, your opponents, you know, in a situation where you actually want to hear them. You're sort of testing the audio connection so that it works rather than doesn't work. And so it's actually very helpful to warm up the environment for the virtual hearing. Moving swiftly to the next point, which is what is your underlying goal as an advocate? The underlying goal is to have a successful hearing, right? And what does that mean? That means from your party's perspective to think that and come out of this hearing and think that you've had a full opportunity or reasonable opportunity or some iteration, depending on which rules govern you, to present your case. And even if, then you ask yourself the question, and this has come up prior to, even if you have the most seamless virtual hearing, there are other tactical factors to think about. So we talked about, you know, some parties being in the same jurisdiction as one tribunal member and whether that has any prejudicial value or impact. And I mentioned that in the context of the tribunal in particular, whether that might be a disadvantage if two members are in one place and one's in the other. The other question is, what if there's an unrepresented party or there's a litigant in person, if you like, or a non-lawyer party representative, or even an advocate who doesn't have the backdrop of a full system to support them coming up with all these points and having the backup of an IT facility or an associate watching you, you know, on another platform to make sure that you're coming across okay. you know, are these factors things that you need to think about, and do they interplay with the fairness point? I come on then to wrap up, anticipating the potential pitfalls. And I say this either to avoid them, because of course, as best you can, you want it to go smoothly, or in my case, as I've already experienced, just to find an elegant way to deal with them, because sometimes you just can't avoid them. Of course, the practical, or I guess the precursor point is there a contractual point here? Do you need, as lawyers, to start thinking already about whether your contract should include express provisions to allow for virtual hearings? So that's your starting point, is you don't want to be having this battle at the time of the hearing. There's technological issues. So I talked about doing test runs and choosing the right provider, having institutional support, which I really think is key. And here, what I would say is that there's the real technological issue for an advocate is thinking about your various focal points. So there's speaking into the camera, there's reading the live transcript, and then there's somewhere you've got to actually have your own script and your own bundles to think about where do you put everything and how many gadgets do you need. You know, Amazon takes 14 days to deliver sort of iPads these days. So you've got to factor this in advance. Logistical issues. So, you know, I'm in the comfort of my home with all my files to hand and my team on the internet. So actually, in one sense, it's even more available than if you enter a hearing room and you've left some stuff at the office. So in one sense, you've got a wider platform available to you. But then, in this case, there's every chance that as I'm talking, my twins will break open that door and come dashing in just as I'm making my best, most important submission. So how do I prevent that happening, as opposed to I've got the fantastic team behind me watching that I'm doing my bit as an advocate smoothly. That point about family and natural sort of interjections, I don't call them interruptions because we love our families, is it goes to a point that actually Kent made when we were preparing for this, which is the importance of mute and the importance of having someone who can sort of watch you, who knows you and sees trouble on your face and excuses you for a moment when you go and lock the door and say, I'll come out at dinner time. How do you deal with foreseeable logistical problems? So Andy Pullen asked a question in this forum about what's the most effective way of communicating with a team who are in different places while you as an advocate is speaking. There's a couple of ways around that. So some hearing providers will tell you that a virtual breakout room is the best way, and we've done that. And the test facility for that is critical, is what I would say, because of course your virtual breakout room itself involves 6 different screens, and suddenly you can't recognize your colleague you've been working with for 3 years because their backdrop is a cloud or something. The other way, I think, is a sort of simultaneous WhatsApp group. I found that that's actually worked really well. And an extra tip here that I found works incredibly well is to disable the auto lock feature so that the WhatsApp doesn't lock and you have to keep putting in your password to get back into your gadget. And the other thing is WhatsApp on iPad or on the laptop. So if you have it loaded up on a bigger screen, then your WhatsApp messages from your team are actually catching your attention and they're not conflated with WhatsApp group photos from the family of how they're dealing with the breakdown. So you can just focus on the WhatsApp group that's most important to you. So those are some ways. One other way is actually having a silent moderator. I know SIAC does this for these types of talks, so that's quite helpful, is somebody in the background who's actually probably most attentively listening, capturing, and dealing with emergency situations. So just to conclude, obviously there are other ethical issues and tactical issues that come into play, procedural issues, should you have a pre-hearing call? Should you adopt some of these protocols into your terms of reference? But what I would say is there's already a lot of learning from the past. Virtual hearings existed and we're only refining them. This is a time of testing, but I think a classic of our community, we've not only responded quickly, but I think effectively. And what I'd say is, although the future impact of COVID-19 is uncertain, I think the ability to continue more effectively as an advocate virtually against such uncertain times is actually looking more and more promising by the day. So that's what I have to say. I'll see if the others have something to add.
Yeah, I mean, sure. Now, look, a lot of information to digest. I agree with all of what Sheila said. I mean, one of the things that we haven't touched on, maybe I'll touch on that, is really the confidence levels that people have, particularly when it comes to evidence, right? And by that I mean, if you think back to cross-examination of witnesses who aren't in the same room as you, and you've done that virtually through video conference, for example, most of the time what would happen is you would have someone in the room with that individual. That was the traditional method, ensuring that that individual wasn't being assisted in any way in the evidence that that individual was presenting. Now, obviously, it all sounds primitive when you think about it, but it comes from a concern that the evidence could be tampered in some shape or form. Now, obviously, there are ways around that too, to some extent. COVID makes that even more complicated, but maybe my co-panelists will talk about this as well, as to how one can go about making that a bit less of a concern, and whether you can have a 360 view of a room, for example, to ensure that that particular witness that's being cross-examined is giving his or her own evidence and is not being assisted. Kent, do you have any thoughts on that?
Yeah, I think it's a real concern. In some cases, more than others. And so the arrangements we have in place for our next hearing involve someone from one of our remote offices attending the witness and making sure there's nothing untoward going on. They're not threatened or intimidated, or they're not having the answers planted. And this process, the integrity of this process is protected. Apart from that, the 360-degree camera, the back and forward camera solution seems to be about the best we can do in an imperfect situation. But I think with a lot of these things with virtual hearings, there's no single correct solution. Depends on the witness, the evidence they're giving, the jurisdiction they're giving it in, what sort of issues are in play as to what the risk levels are. But those are the solutions that we've seen.
Right. So both Nish and Sheila mentioned that there might be some delay tactics used by some party. So we actually get one question from the attendees. So he asks, what unique fact patterns justify adjournment in favor of an in-person hearing? I know obviously COVID-19 is something we cannot resist, but are there any other circumstances?
Sheila, do you want to take that, or
Sure, I'm happy to start, and you can add on to what I say. I mean, I think I mentioned earlier that some jurisdictions obviously feel that technological disparity between parties is a very compelling factor, and we're all, I guess, living and working in a world where we sort of assume that somebody will be able to pitch up virtually and represent the party adequately. But I think one really has to ask oneself whether it's really always the case. And that's the most obvious situation in which somebody can be quite outrightly denied a proper hearing if they don't get to choose their own party representative because they don't have the right technological ability. I think the only other thing that I can think of is where you have so many different facets in terms of so many different parties to a case that you can't properly see everyone at the same time, and you have to. And actually, I've seen this in a different fora where we've actually had to think about whether a large group setting is really feasible, because the eye contact and body language is really important. And of course, you have advocates speaking one by one, but partly, and you see this in physical hearings all the time, where one party makes a really good point against the other party's case, and you see the tribunal immediately turning to see the other side's reaction. And if they feel that they won't be able to get the full extent of the momentum of a hearing virtually because there's just too many people that are relevant, then that's another reason why I think they may say it's just hard. I don't know, Nish, whether you have something to add to that, or Kent.
Yeah, I mean, I think it will depend. It goes back to the point I made earlier, right? If, for example, credibility of a witness is crucial, and you feel for one reason or another you're not going to be able to effectively cross-examine, whether because of technological difficulties or other difficulties, that's one. The second is for very large hearings, for very large matters where it could be document intensive, for example. It could require physical examination of materials, for example. It could, you may need the time to come up with an alternative method. So ultimately it may still be a virtual hearing, but in order for that virtual hearing to be effective, you need to come up with an alternative method of presenting that evidence and presenting those submissions. And that might just take time. And for a sensible tribunal that understands what's required for the case, I think they will accept that as a reason for an adjournment, for example.
Thank you, everyone. As a very strict timekeeper, I know that our session expires, but before we finish, and also as requested by many of the attendees, Sheila, could you please repeat the English case name? It's my note says it's one party versus BHT.
It's Municipio de Mariana and others versus BHP Group PLC, and it's 2020 of the High Court of England and Wales 928. So that may help with the citation search.
Thank you very much. We are very grateful for your contribution, and to all attendees. In the coming months, we're going to have more webinars, so please stay tuned. Thank you very much and take care. Bye bye.